Good afternoon, everyone. My watch says it's 1 o'clock, and we have a quorum, so I'll call our OVA July 15th board meeting to order, please. May I have a motion to adopt the agenda as presented in your iPad documents and available to residents at the back of the room. Moved by Bob Giddings, second by Fran Diaz. Adopted the agenda. Move on quickly to the members' open forum. Anybody have some counsel, advice, or criticism that they'd like to offer?
Harriet Paul, 634.
I'll use Kathy's. Harriet Paul, 6347 Meadow Ridge Drive. On Friday night, I got a call from a friend who asked me if I thought it was true, as he had heard, that the tot lot was on the agenda for today's meeting. I studied the agenda carefully, saw nothing that said tot lot. I then reminded my friend that after careful study and analysis, the LRPC made the determination that a tot lot wasn't a good fit for Oakmont and that it would not be included in the long-range plan. The issue seemed settled. How naive could I have been? I subsequently learned that whoever put together the agenda expediently used the word petitions instead of tot lot petitions. It didn't occur to me that an agenda item of such importance to so many wouldn't be clearly titled. And why did I think it was a settled issue? Because the LRPC had made its decision. It is my understanding that the various committees exist to advise the board. Once a committee has sought input from the community and weighed and measured and studied all that it knows about the issue, it seems to me there should be respect for the decision that the committee makes, unless it turns out that it missed certain pieces of evidence or that erroneous evidence was introduced. Apparently, in this case, the veracity of some of the resident petitions that were introduced is being questioned. I believe that the decision not to include a tot lot in the long-range plan was not determined by the petition. I urge the board to ask the LRPC to drop the petition portion of introduced evidence and reassess the evidence that remains. I am convinced that it will come to the same conclusion. A tot lot is not appropriate for Oakmont. Thank you so much.
Hi, Eleanor Brodnansky, Oakmont Drive, 7495 Oakmont Drive. I want to talk about bees. Our manager pointed out to me that some residents are worried about bees because we have crepe myrtles planted out here. Well, the bees like some of the other plants.
Mike, a little closer, please.
I'm sorry. The bees also like some of the other plants that are around here, but we really need the bees, and they will not bother anybody if you don't swat at them or butt them. They're just after the pollen. So I just want to assure everyone that we shouldn't have a problem with anyone getting bit by a bee unless you aggravate them. Also, we're happy to have the bees here because in taking out the rosemary along the first median, we had a lot of complaints that, oh, the bees are going to go away. So we just really can't please everybody, but we're trying. Anyway, that's all I have to say.
Thank you, Eleanor.
Wally Schilt, Bellhaven Court. I just wanted to comment on the article, our interview with our manager in the PD last Sunday. And I've received a number of phone calls from people who were dismayed with it. My personal opinion is it was perfect. We are run down. We've been run down for many years, and we have been addressing this subject for a number of years, and we're getting back up there again. I had people that said, oh my God, nobody's going to want to buy in Oakmont when they read that we're a rundown place. Well, that's not what the article said, and if you think it did, go back and read it again. It was just what we needed to keep our property values up here. The fact that we are going ahead and bringing this up to date. And if, I also had some people that said, oh my God, she's catering to the boomers. I don't think you can really say that. The boomers are going to be the majority here pretty quickly. And us older people better remember that. And the fact that we might want to put in some new and different athletic areas such as pickleball, that's all good. It doesn't hurt the older ones who don't want to play. They don't have to. They're not taking anything out, except possibly the horseshoe pitch. I played there once in the 15 years it's been open, and I've never seen anyone else there ever. So those of you who are complaining, I think you need to reread that article.
Thank you for your comments, Wally.
Can't hear you.
Hi, I'm Meredith Thompson. I live on 429 Oak Brook Lane, and I do agree with what Molly said. I thought the article was lovely. And we boomers are going to be not boomers forever, I'd like to say. Anyway, I'm here about the petition being public, the tot lot petition being published. My concern, as one of the women who went out and knocked on doors and got the names, many people who signed were reluctant because they didn't want it published. They were afraid, and what the concern was that, well, if my neighbor wants it and they see that I don't, we don't want to have hard feelings about this. So, in fact, many people didn't sign for that reason who were opposed. So I am against the publication of the names, and I agree with Harriet that if necessary, the petition could be withdrawn from consideration as far as the Long Range Planning Committee. I do not believe we need a tot lot here, and I would be willing to take people who come here from out of state to Howarth Park and Kenwood Plaza and show them what a fabulous, fabulous area there is available for kids to play. Very state-of-the-art that the cities have put in that we could never duplicate. These places are fantastic. Just take your camera and your little ones and make a promise to them that you'll return every day because they won't leave unless you do. But I think that Oakmont is a fabulous place to live, but I'm concerned about the process that lacks as far as presenting these new changes to the community. I would like to see when these things come forward from the beginning, and I would like to be able to give feedback and have a forum where that could be done for the public so that we could all discuss this as a community. I think it would make for a friendlier atmosphere, and it would make for us to get things done in a more timely manner and not pit one group against another. I think we need to be more community-oriented and respect each other's opinions. And hopefully you'll come up with something open that we could all participate in. Thank you for the work you do.
Thank you for your comments. But I thought boomers could be forever. Maybe not in body, but in spirit.
Bye.
Ingram.
That thing on? My name is Ingeborg Tieske, 7009 Fairfield Drive. Talking about property values to be kept up. I requested about 2 months ago that people should be checking into limiting the amount of rental properties in Oakmont, like many other communities have long time done. Berger didn't have any need for that because here came only people in the beginning who were willing to buy. Lots of homeowners do not have any intention of ever moving into Oakmont. They just rent their places out over and over and over again. We are now on 24% of rental units. I think this should be about the limit, and I would like to know if anything has been done about it, and talk to Mr. Malcolm, our lawyer maybe, how a policy can be put into place to limit rental units in Oakmont. So I really would appreciate a reply to that sooner or later, especially since you are setting goals.
Thank you. Your question is about a complex subject, and we don't have it on the agenda today, but I will talk with the other directors about how we should address it in the future. Are there any other?
Okay, my name is Bridget Mulanari. I live in Dornbridge Road. And I'm talking about the petition that's supposed to be made public. There is no procedure or rule adopted by the association regarding the petitions, and should not be. For the last 20 years, we have collected petitions with names and addresses from the members. Nobody ever requested that the names were made public in the paper. This is the first time. The results from the petitions were made public, but no names were revealed, because many people don't want their names out there. Now the president is trying for us that the last petition should be published. We talked to him and he told to me this was a democratic way.
Speak into the mic, we can't hear you.
Okay, is this better? Yes. Okay, Mr. Taylor, then I want to remind you of something. When you put the drawings out for the proposed new business center there was no suggestion box there. The people came and asked you for it over and over again. You finally allowed them to have the petition box. After a while, they were taken away. Nothing came of it. The people asked for a tally of it. They had to go over and over again until you said, okay. So they got the tally back. There were 286 people for that. However, sir, it never ever got published in the paper. That is not the democratic way either. Thank you.
Thank you, Richard. Your reminders are helpful. Any other comments? We'll go on then to item 4 on the agenda, and that regards announcements. I wanted to share with you that last week we received from the city a design review approval for the proposed project at the West Rec Center, and we are now in the process of answering about 25, what I choose to call nitty-gritty questions from the building phase of the Community Development Department about the actual plan check work that they do prior to issuing the building permit. Our maintenance manager says that there are no significant issues that we're going to have to deal with in responding to the plan check, but we still do not have a building permit, and we're anxiously hoping that we can give the city the answers they need as promptly as possible. That having been said, we are still hopeful that we could begin the project there by the middle of September, and hopefully it would fall then into a 60-day or so time frame in which we could accomplish the work. But the actual addressing of questions of how to make room elsewhere or to ask for a closure of some of the activities that go on at the West Rec Center during this construction period is a question that we won't be able to fully address until we get responses from those that bid on the project about their feeling regarding the scope of the work and the safety that we need to assure residents while that work is going on.
Excuse me, John.
Yes.
I have a question. Are you saying that we're actively pursuing bids for the work in advance of getting full approval of building permit?
No?
Okay.
The second announcement that I wanted to share with you is that MLK Senior Living, who are the owners of Oakmont Gardens, have reached in principle an agreement to purchase 2 parcels from the Hunter Group. I say agreed in principle because, like most of these kinds of contracts, you agree on the money, but you also have a conditional feasibility study period to do your due diligence about the property. But it would be encouraging if, as we saw 36 houses being built and the general landscaping of that long weed-filled parcel around the gas station improved, if the 2 parcels that the MLK group are negotiating about could be built. And when I say 2 parcels, one of them is directly behind the present Oakmont Gardens and is zoned for assisted living development. And the second one is a 15,000 square foot parcel that's zoned commercial that is immediately adjacent to the OVA offices and the medical building. And I understand that development of the assisted living facility might require use of that parcel for additional parking that would be associated with that development. So we'll cross our fingers that something long sought in the way of that kind of expansion to serve the community's needs might truly go forward. Any other announcements of the director? Mike, please do. John Felton has been spearheading our work with PG&E to get approval for doing the transformer and electrical switchgear project.
And that project is moving ahead as we speak. PG&E is going to be with us on site Thursday morning, just where they can see physically where we're going to be doing this work. They're having some question about putting equipment in of the style and shape, aesthetics that we wanted, and they wanted to essentially keep it the way it is and put another big box inside of the fence, and that's not something we want to do. We went back and forth, and I'm happy to say that we came up with a win-win situation where it's not going to cost us extra money to get what we want, and the project is moving ahead very quickly at this point.
John, I have a question also. Is there anything that you made announcement at this time with regard to gardens and the Hunter Group getting together and developing memory care units in the immediate vicinity of the garden?
I don't know of anything we can do at the present time. Going on with the agenda, actions taken outside the board meeting over the 4th of July weekend, the very old heater for the spa facilities at the central pool died. And in one sense, that maybe is a fortunate demise because replacing it gave us the opportunity to relocate it in the pool spa equipment room to a location that would let us better rehabilitate the electrical panels that are in that complex. And so I authorized on the 7th of July an expenditure of $8,062.78 so that we didn't have that equipment out of service any longer than possible. And next item on the agenda is the consent calendar. Before calling for a motion to approve the consent calendar, I'd like to make two corrections in the minutes for June 17th. Item 3B, the new general manager for the Oakmont Golf Club is Mike Ash, and he's from Vacaville rather than from Pleasanton. And he's actually an employee of Kemper Sports, which is the management company that OGC has contracted with to run the OGC properties.
Mr. President, I spoke with Kathy earlier, and the version of the minutes that are attached and are subject to approval today are a draft and are not the final version. I would request that they be removed from the consent calendar and submitted the next meeting at which I can review and finalize.
Thank you. That helps make the corrections. No objection. We have a motion to approve the consent calendar with the elimination of item 6A1. Moved by John Felton, seconded by Herb Hess. All in favor? As part of the consent calendar, I'd like to comment that it's nice to see some really qualified new appointments to working on our communications committee, our landscape improvement committee, and on our architectural committee. Appreciate the kind of time that it takes for those that serve on committees to help with that work. Next, we have the treasurer's report.
Okay, for the month of June, we had revenue of $173,000 with expenses of $189,000, leaving us with a deficit of $16,000 for the month. On a year-to-date basis, the revenue was $1,025,000, which is 1% worse than budget, and expenses $987,000, which is 5% better than budget, leaving us a surplus for the first half of the year of almost $39,000. The transfers to the funds were all equal to budget. The impact fees from the developer of the orchard, year-to-date, they have sold 7 homes, 1 in June, and there's 5 homes left to sell. The cash in the various accounts, the operating fund, $599,000, asset replacement, $798,000, capital improvement, $1,452,000, catastrophe, $106,000, leaving us total cash of $2,955,000. Also, on a quarterly basis, I'm required to report to the board the status of the asset reserve fund. In 2014, the monthly transfer was increased to $42,667,000, and we've transferred that exact amount each month and will continue for the rest of the year. It's also a requirement to review the bank reconciliations quarterly, and I have reviewed those bank reconciliations. Also quarterly, I'm to report the cash position. In May, we cashed in 1 CD and transferred it into the asset replacement cash investment account for $300,000. All funds are fully FDIC insured. We have CDs with interest rates between 9 and 83 basis points, and savings accounts between 10 and 20 basis points, and several non-interest-bearing checking accounts. Any questions?
I have a motion to accept the treasurer's report. Moved by Andy, seconded by Herb. All in favor? Did I speak wrong? Oh. How many times is that, Alan? Are you keeping score? You should. I apologize. Next item on the agenda is the manager's report. Cassie, do you have any comments other than what you wrote for us?
The only thing I would add to this is I wanted to let everyone know that the East Breck furniture is being donated to Crossing the Jordan, which is a youth nonprofit organization, and they're very thrilled to get the furniture.
Any questions from directors about the manager's report? Any inquiries from the audience? Thank you. Go on to new business items, since there are no additional reports beyond those that are in our board packet. The first item of new business is to adopt the OVA board goals for 2014. Members of the audience have a copy of the summary of the goals meeting that we had on Monday, the 5th of July. I think that was a very productive discussion. Cassie and I worked to summarize that information, and you find it on the page in your board packet. Are there any changes that you would wish to propose in the way we summarize those goal items? May I have a motion then, please, to adopt those goals as they are presented? Moved by Andy. Got the name right? Seconded by Bob Giddings. All in favor? The next item on our agenda has to do with the request of the Long Range Planning Committee for the board's conceptual endorsement of an OVA survey. In your packet, you'll find a lengthy Long Range Planning Committee report to the board, which includes suggested draft motion that they would like us to adopt. Draft motion reads, the Board of Directors of the Oakmont Village Association hereby endorses and supports in concept the preparation of a community research project by the Long Range Planning Committee. The research project shall be part of the proposed long-range plan for Oakmont and shall be approved by the board prior to implementation by the committee. The Long Range Planning Committee shall have no budget at this time and no authority to incur costs on behalf of the project or in the name of the OVA. The OVA Board of Directors will, however, consider the question of a budget for the Long Range Planning Committee effort upon submission of a request for future expenses, and which provides a full description of the nature and purpose of those expenses. The Long Range Planning Committee will have staff support through the manager's office, incidental and reasonable expenses such as a photocopy or use of the OVA website or Oakmont News. These shall be provided without charge to the committee. May I have a motion to adopt the draft resolution submitted by the Long Range Planning Committee, and then we'll have a discussion.
I would so move adopting the motion you just read.
Moved by Bob Giddings, seconded by Alan Scott. Questions on the part of the board regarding the committee's request?
John, I don't have a question. I just want to speak.
Please.
I'd like to read but this presentation by Long Range Planning Committee, was it up to the quality that we've seen?
Louder.
It's up to the quality that we've seen from this committee from their inception. And they have included, as everyone on the board knows, a draft of the project research here. And I, as one board member, feel some gratitude toward the quality of people on this committee and the quality of the work that is being presented, not to the board, but to the Oakmont community. So thank you so much. And I look forward to further discussions and further meetings with the Oakmont Long Range Planning Committee.
There will be plenty of that.
Any other director comments or questions? Mr. Chairman?
Yes, my name is Tony Lockowitz. I'm the chair of the Long Range Planning Committee. And I want to thank the Board of Directors for two things. One, for considering the motion that's before you today to endorse our proposed research project, and also to place on your list of goals for the coming year or term to support the long-range plan development and research. and we certainly hope we can live up to your expectations. With regard to the community research project, we've only just begun. We've had one meeting. We have had interest from residents who are experienced in doing professional research projects, public opinion surveys and the like, and who are going to volunteer their time to assist us. The chairperson of that research project subcommittee is Lisa Berman, who is a member of our long-range planning committee. Lisa, could you just tell us a few things about what we're going to be doing?
The first thing we've done at the direction of the Long Range Planning Committee is we have set up a Community Research Project Steering Committee. On that committee are several members of the Long Range Planning Committee, but also appointed have been 4 other people in addition to myself in the 5-member steering committee, and that would be 3 people who have spent their careers doing professional research, and also board member Andy Altman. It's a very high-level committee that everybody really knows what they're doing. So we had a very, very good first meeting of the steering committee. We all went home with roles and responsibilities. We'll have another meeting a week from Friday, and we'll probably be meeting fairly intensely until we can get this project underway. The first big initiative we have to undertake, however, is to get email addresses for, we hope, virtually everybody in Oakland. Because for cost and efficiency reasons, we need to do this by email. That doesn't mean we're not going to approach people in other ways with mail and or having computer centers set up or go door to door. We're going to look into all of that. But the most efficient and effective and cost-effective way to do this is by email. So you'll be seeing an effort coming forward very soon to start to gather emails. I know Cassie's mentioned this in her newsletter. Whatever anybody can do to help us get emails would be appreciated. You'll hear a lot more as time goes on.
Thank you.
Mark?
Lisa, Tony, when do you expect that you might have the format of a survey that could be looked at by the board, and do you have a feel that at that time you will have an estimate of the cost?
I just want everybody here to understand that we're calling it a research project because it's multimodal, which means we're going to be doing informal focus groups, formal focus groups, a survey, stakeholder one-on-one interviews, and public forums to try to get everybody to come out and register their opinions on various topics. The first job for the committee is to try to figure out how to get email addresses. Meanwhile, several of the professionals on the team are looking at various ways that we can do this and how we can save costs. And we'll have that. I hope we would have something along those lines within the next couple months. Couple months?
Thank you. Other questions? Thank you very much, Lisa. Thank you.
You're welcome. Thank you.
We have a motion to adopt the resolution as I read it. All in favor? Motion passes. Item 10C is on the subject of the East Recreation Center removal of a pool table. You have in your board packet a copy of a petition submitted by Carolyn Ewer and Pat Warner regarding a subject they characterize as the pool room upgrade. And in your packet, you also have drawings that show you the present layout of pool and billiard tables in that room. And because we now have iPads that can give us color pictures of the situation as well as those drawings, you've got an actual photograph of how that room, designed in 2009, was structured to accommodate the 4 pool tables that the then users of those pool and billiard tables insisted was the requirement. I put this on the agenda as a discussion item rather than an action item so that we could all fully understand what might be involved in this particular activity. This petition, I know, has about a dozen names on it. Since there are no involved. It's a discussion item. What's your pleasure on how we proceed with this request? Yes, Mr.
President, is there anybody from the audience who could respond to this?
Alan is asking, is there anyone in the audience from the pool group that are petitioning to have one of the pool tables eliminated? There is nobody here. John?
Just in general terms, I don't know, has anybody on the board play pool over there? Neither do I. I think
We've got no petitioners and no board.
right. I mean, I'm totally neutral. I don't feel one way or the other, except I do feel that if it's the users are the ones that have a vested interest, and if they recommend this change, I'm sure maybe not all of them agree, but the majority that we should accommodate that change as they request.
Alan?
Aye. Go ahead.
Are the plans such that,
Can't hear you.
Your microphone is not on it.
are the plans such that the excess pool table, 4x8 table, when we get around the point of disposing of it, would it be picked up by someone who's interested in buying it and also removing it? Because removing that is a horrendous task, and you have to be very, very careful about not breaking the slate base within the surface of the table. What are the plans to dispose of it?
Alan?
The petition addresses that, and that whoever either purchases it or accepts it as a donation should have the ability to adequately move to their new facility. I thought this is a wonderful petition and answers all the questions, and I agree with John, we should adopt it. It's not costing us money, it's actually improving the situation without costing money.
I agree with what Alan said. They have signatures of regular users they report. And it's not too many recommendations we get that say the flaw in the situation can be easily remedied, no cost. That's something in its favor also.
It's a really detailed analysis of the situation and presentation of the solution.
I think the subject that's not addressed is one of the specific value of the product, of the asset that the OVA has, and whether or not the accommodation that's being requested means that we should give away a valuable asset. And the absence of that information leaves me wondering how we should proceed.
I was thinking that we would need to appoint somebody to look into that specific thing. That's why I was hoping a petitioner would be here so that we could have a foreign body to go out and look for that answer. Otherwise, we should maybe send Cassie or have her delegate this to somebody to find out if it does have a value and if we can market it or if we need to donate it.
I think the other aspect of this, in my mind, Alan, is the design that is there now was required by the people who played pool when that building was remodeled, to the extent of taking out pillars, putting in entire cross beams, and assuring that we could in fact accommodate what they felt was the minimum number of playing tables that the community should provide for. And now we have a migration since 2007, when that work was done, to people who now say, well, there's not that many of us playing, and we bump fannies when we have people playing on adjacent tables, and so it would be more comfortable if we had more room. I just don't know what our responsibility is to respond to the waiving changes as far as we have a resident who wants to speak.
Pat Amadeo. I actually was involved in the placement of those pool tables under the East Rec. It was part of a sequential series of decisions when we were building the central facility.
one of the first things we had to do was to move the pool tables, which were on the first floor, the bottom of the West Rec Center. And there were a number of pool tables there, but there were about 60 people who used them, but they used them sporadically. In order to convince them to move under the bottom of the East Rec Center, those pool tables were acquired. They were all brand new at the time, and I can't tell you how expensive they were, but I think they were a pretty penny. But that was the trade-off we made to lure them out from the bottom of the West, because we thought there was a better use there. It was tight from the beginning at the bottom of the East, but you're correct. We made a number of structural decisions, which were also pretty expensive, in order to accommodate what we thought was the use at that time. It's just some background that you should have if you didn't know it.
Thank you for clarification.
President, maybe there could be some kind of notice to the public so that anybody else that would have an interest in this would be aware of this proposal before any action is taken on it. The second thing is, I noticed in the photograph that all the lighting in there is structured to accommodate the present configuration of the table, and that will trigger an expense.
Paul, I just hope that 1 year from now, people coming forward and saying we don't have enough pool tables. If you take one away, you will say that's just too bad.
I'm looking for some further expression from the board as to who should lead the effort. I think publishing more information about this item being considered, making sure when we put it on either our workshop agenda or future board agenda, that we have spokesmen for the players to help us address some of the kinds of questions. Bob, you have a comment?
I think all the points are well taken. If it was ping pong, it would be less of a problem. We just hold it up and hold it into a closet sometimes. But we're dealing with a large, heavy, expensive object. I think the lighting, the way it is, would have to be redone. But I see it's just hanging fluorescent, and that could be moved around off a suspended ceiling. If it is a suspended ceiling, sure. But I agree that we should have a representative there, and we should find out what the cost of it is. And if there's a possibility, we could store it for the perhaps time when people come back and say we need an extra pool table.
Can you see if you can get us enlightened further for our workshop in August? Any objection to that approach? Thank you. So we'll pass on that item in terms of asking our manager to get us further help with the value of the asset, any removal costs if it were to be removed, and questions about the lighting of the region, and the long-term demand for 3 versus 4 pool tables. Thank you. The item 10D on our agenda is to address one of the issues that's on our secondary goals sheet. And that has to do with an ad hoc study committee for the Burger Center. And that means the entire Burger Center. We have to come up with someone being responsible for developing a charter, identifying potential members that the board could appoint to work on an ad hoc committee. But for the background of the members who may not be up to date on this situation, in the course of the directors working with the manager and the facilities maintenance manager touring our facilities the past couple of months, one of the places that we spent a great deal of time was right in this building, looking at the nature of all the conditions, whether it's the wood dance floor with the tape there in the middle of the aisle, and the asbestos removal that will be underneath it when that needs to be replaced, or whether it's the side carpet that also has the asbestos issue, or whether it's the tile down the hallways or into the kitchen. The whole subject of the nature of the flooring in here was one aspect of this building that we looked into. Another was the question of the single pane glass windows and the current code requirement now for triple pane windows and the potential for energy savings and sound improvement so far as use of the Berger Auditorium is concerned. A third element was a question about whether or not the ceiling-high doors that we have on three sides of the building are really the best accoutrement as far as this building is concerned. Further questions about insulation in the upper area, whether or not the fireside room with a fireplace that hasn't been used for eons is going to serve as best in the long run, or whether some kind of adjustment there needs to be made. And I'm sure there are others that came up that I don't need to repeat for you, but the question that came up in connection with all of those is, are we best advised in looking forward over the next 10 years to simply treat these maintenance items one by one? Or should we, in fact, take a look at what the real future of this building should be to best serve the community, which, in addition to the kind of things I've mentioned, might include at least the investigation of some substantial remodeling of space, whether it was to provide a true lobby entry area, whether it was to enlarge the meeting rooms that we have on either side, or facilitate better entrance to those meeting rooms so that the bigger part of the auditorium isn't influenced by what goes on in those meeting rooms or many other uses. And so, as I see it, in order to fulfill that secondary item on our goal list, we need to have a board member step up to the challenge, or a pair of board members step up to the challenge of writing a charter and bringing the board members a suggested list of committees. Alan? I don't think I need a motion. I'm glad to appoint people who will take on those tasks.
This was my idea to get on the agenda that I'm concerned about.
Alan, we can't hear you.
Sorry about that. I would very much like to be engaged in this activity as a co-chairman or tri-chairman of the committee that is involved in formulating the charter and involved in the committee thereafter.
Thank you. I appreciate that. And may I then ask that before we talk about appointing a chairman, that I ask Andy and I ask Alan and Andy to collaborate on the preparation of a charter. Secondly, to collaborate on the development of a list of names of people who would be willing to serve on the committee. Since this appeared on our agenda, Tony Lakowitz has contacted me and said he would hope that a representative from the Long Range Planning Committee could be considered for membership on a committee that he would be appointed. I've also had an email from Noel Lyons expressing interest in being considered for membership on the committee. I've already talked to Lynn Kramer, who is interested in working on this activity. And I talked to Jim Sinar, who said he'd be willing to consider it depending on what the charter was developed to accomplish. And Cassie has mentioned to me that Heidi Klein would be interested in working on the committee. So there's a starting list, at least, that has come to my attention of possible names. So if by the time we come to our board meeting on a month from now, we could have both a charter and a recommended list. And I, for one, would hope that the charter could really be as as full and complete about what we'd like to see the committee accomplish as possible. Maybe a draft circulated at our workshop so that other board members could provide you some input finally before we get to the actual board meeting action a month from now. Is there support for that program? France?
Mr. Chairman, I'm not going to answer exactly what you suggested, but I wonder if you could explain a little bit what this charter is. We haven't adopted a charter for other improvements within the community, and why is it that we must have a charter for the Burger Center?
I think they may have escaped your notice, Fran. We appointed an ad hoc pickleball development committee, and I actually drafted a charter, and we adopted that as a guideline for that committee to work, and it included appointing Cassie as the chair. So under the association policy for committees, the board is charged with preparing a charter to describe exactly what we want that committee to address as a responsibility in appointing the committee.
Wouldn't they do that naturally?
Well, I don't know. I think, Fran, the thrust of that is if the board's going to appoint a committee to do something, it ought to reflect what the board wants the committee to do, rather than having the committee decide what they want to do. Then Andy and Alan will look forward to some preliminary information at our workshop. Thank you for volunteering. Item 10E is regarding the adoption of a fine policy and a hearing procedure to enforce a fine policy. It's on our agenda because at our workshop, we reviewed communication from legal counsel about what a policy should include, and you all have a draft in your packet of that policy statement. And I took the liberty of adding one item to it on page 2, which is highlighted in red, and I did that for discussion purposes, not as a sense of direction. I did it because the report that the fine committee made to us emphasized what they thought was the extreme importance of at least having a specific fine penalty for residents' failure to submit and receive architectural application approval before making changes. And so I just arbitrarily put that in ahead of the category of first fine violation, second fine violation, etc. And I just arbitrarily picked $50 just to get the discussion going. But I believe that the intent of our discussion at the workshop was to decide if we want to approve this in some form in order not to adopt it, but to approve its publication for the community so that we could get community comment about taking this kind of a step forward in changing the culture as far as Oakmont's architectural procedures are concerned. So I'd like to, I'm open to motions, I'm open to comments, whatever you would. Bob?
I would have a comment just because the audience changes with each workshop and each meeting we have, and our thoughts change too, but this, and I don't want to put words in the committee's mouth or in Annie's mouth, who's been working so hard on parts of this or all of it, but again, the architectural violations and the architectural guidelines are the sole world of the architectural committee. The board does not involve themselves in the guidelines and enforcement thereof. We get involved when that's referred to us by the architectural committees for violations which can't be solved. And is it worth saying here that once again, that the fine structure fines are applied by the OVA board only and not by the architectural committee. I know that's a repeat, maybe the fourth or fifth time, but I think it is always useful for us to keep that in mind, a separate thing. And throughout the process that occurs in a violation, the equanimity and due process which the architectural committee affords the person remains the same and fair, and the same procedure the board has been using when having discussions with the person who's in violation. Those remain largely the same. That this fining is the new thing. The adding that schedule of fines there, and that is once again the property of the board, really, at that point, not the committee. If I've misspoken or misstated something, please correct me.
No, the only thing that I would like to add at this point, Bob, is that I believe the board sees this particular subject on our agenda today as simply one of several piece parts of what needs to be done before such a policy would be implemented. That we've got some work that we want to do regarding, or we want the architectural committee to do, regarding the guidelines to take out some of the subjectivity that are there to make it more understandable. And our manager is in the process of developing a complete handbook to use as an introductory process for new residents to make sure that they get a full understanding of the significance of our architectural guidelines. So we've got several pieces of the puzzle before any of this will be implemented. We're trying to further the process of community input by deciding whether or not to publish what you have in your packet today. And if I'm off base, please. Andy, did you have any comments?
I do have some comments. Thank you, Bob, for clarification on some of these things. There are a couple of new, in the policy that's drafted that we have in our board packets today, monetary penalties, which is B in the possible remedies, 2B is new, but there's also some other new things that got squeezed in here I wanted us to be aware of. We wanted to make sure we wanted those in the policy going forward. They're not in today's world, which is also 2D. We don't have suspension of voting rights in the architectural guidelines and standards right now as a possible penalty, or not penalty, but disciplinary thing. So if we're going to have all 7 of these, we have to make sure that those are the ones we want, those are clearly documented.
Do you think that some editing of these points should take place before we publish the document for community input?
I don't, because I believe we wanted this policy to be used for disciplinary reasons regardless of any governing document violation, not just architectural violation. So I would expect that we'd want all of these types of disciplinary measures to be available to us. I just wanted to point that out because if the architectural committee uses this in their guidelines and standards, when they do the updating, they would then have to also include these as part of their guidelines. Nothing else in this policy changes from what we have.
Alan?
John, I'm wondering if this setup, the system that is being proposed has dispute resolution and alternative dispute resolution hearings in it.
I don't have, well, we've asked for both IDR and ADR to be added in here as possible options.
I beg your pardon?
We've asked that, we've recommended IDR and ADR to be listed as potential options to be used for disciplinary measures because there's a huge difference in expenses.
I think the point, Alan, is if you can go to what amounts to page 2 on the document, and they're referring to item 2F. It takes a while with the iPad to get to the location. I have the benefit of paper copy.
It's 52, page 52.
And I believe that needs to be in there because I don't believe we have a legal, I believe legally we're required to offer IDR and ADR. It's part of the notice that goes out with our annual notification.
Mr. Chairman,
Yes.
I totally agree. The point that I wish to make up, to bring up is exactly what you have stated. I really was impressed with the thoroughness of the information that we received from the law offices, because this is a very delicate thing that we're heading into. And they have been very thorough in pointing out what we can do and what we can't do. And so I think our committee will have plenty of time to look this over and to add only those things that will be readily accepted by the community.
And I agree with that, and I think it ought to be clear that council advised that only the board and the full board, not a committee of the board, has the authority to exercise discipline.
Mr. President, am I to understand that this policy would also cover instances of violation of a policy that the board might adopt regarding the treatment of employees, and that the ad hoc committee that I was involved with covered?
That's the intention.
Well, I don't, this is something prepared by council that Ms. Turner selected that hasn't taken advantage of the benefits of the research of that committee, of the work of that committee. There were a number of due process considerations when you have situations involving individuals confronting each other and having that kind of problem that aren't addressed here. That should be having to do with the right to confront witnesses, things in which there's case law that says that you can't fine somebody unless you have certain considerations included in due process, and they're not here because I don't think it was anticipated when this was prepared that it would involve these kind of one-on-one confrontations that occur when somebody has a rude relationship with an employee or staff person. Another one was that in this document here, for example, it says that the individual who is allegedly accused of a violation can bring an attorney to the hearing. That is something that was discussed and considered, and there's no right for an individual to have an attorney, and there are many associations that do not permit it, and it was something that we decided would be not a good idea to have an attorney. It would turn every hearing into a litigated dispute when they came with an attorney. So that's an example. Okay. So there's a lot of things in this document that don't reflect at all what that committee did.
And would it be your recommendation that we supplement this before we even publish it for community comment to address those elements that you just described? Or should we simply do that as part of the process of refining it after we get other community input?
I don't know. I think that's your call. I just want you to know that there was a whole draft prepared which has never been published because all of that ad hoc committee that I'm talking about gave you with an interim report on a draft fine policy and a draft hearing policy. That's, and this is all just replacing all of that, it seems, without that committee's work being
replacing it or simply supplementing one another?
Well, the work of the committee hadn't even been published, so it's as if the committee had not done anything. Okay, so it's not replacing it, it's not supplementing it, it's replacing it. So I don't know what you want to do, but I mean, we came up with a lot of things that are not going to be, look like they're not going to be looked at.
Mr. Chairman?
Yes.
Is it possible we can make these two separate, that we don't have to write a universal contract that in fact, that these attorneys?
And approach this one just as an architectural control.
That was exactly what was considered by Andy and I at one point as being a preferable approach, is to have a hearing policy tailored solely for architectural violations, because they're so different and unique and they have such freestanding authority. When they bring a matter to the board, it doesn't involve full hearing that would be required if a violation of an abuse policy were brought to the board, which would require the board to have a full hearing with witnesses and all that stuff. Completely different process. To lump them into one is a problem.
And I think also, as a resident, if I have this in my hands or it's in the handbook that is handed to people, if we make changes, the more, if we're considering two things, I think it's going to be much harder for the average resident to understand unless we have a certain policy regarding in the architectural guidelines and another policy for something else. And a resident can immediately see, if they choose to, that one doesn't apply to the other and get traverse both policies more easily. I would think.
Yeah, and there was a whole lot of work on what constitutes, use, and what constitutes something that's subject to a violation, and all of that. So there's a whole lot that's not here.
Thank you for bringing up that. If we were to change the title of this document to read Hearing Procedure, Enforcement, and Fine Policy for Architectural Violations and publish it as that kind of a document for community content, would that serve our purpose?
What if you change this is a
Why don't you include any CC&R violation instead of just architectural violation?
All right with me, I'm not sure I'm following your...
Well, an architectural violation, let's say age restriction wouldn't be an architectural violation, so you'd want to say it was a CC&R violation.
I'm fine with that. No problem?
John, concern would be the implementation. Once policy has been determined, approved, in the interest of consistency, would there be an attempt to be retroactive?
Hold it right up close. There you go. Snow.
Where's the lead? In the interest of consistency, yes. In the interest of consistency, when you implement the policy, once approved, would you do things retroactive as far as violations that have been occurred in the past but not resolved? Or would you give a grace period for allowing for those things to get resolved? Or would it be immediately implemented? Anyone involved at that time would be subject to the requirements of the policy?
I think the range of questions you asked need to be addressed, but I believe council advises against extended mediation periods as part of the process.
And there's no way you could go back and make it retroactive.
No.
Alan?
I'm concerned that on paragraph 2, basically it allows great discretion on the deciding body as to what penalties or what course of penalties to pursue, rather than a series of required steps to take, and then have a decision of a variety of courses of penalties that could be imposed after certain procedures have been done. This is just, it's even in here discretionary as to whether a warning letter was got. You could just start with a hearing. I just think it needs to be redrafted so that the procedure is very clear on how it will happen, and when the decisions will be made, and what will be the scope of the possibility of decisions.
Mr. Chair?
Yes.
Try that one. Before it gets to this point, there's an awful lot of work that has happened, and the owner, the member of the association,
has been given all of the information that could happen downstream before it gets to the board for a hearing. So what we're doing, what we're proposing in this policy is to make sure we're implementing the due process that's required statutorily to be able to enforce or discipline a member for violating a fine. And to have this flexibility is something I think that the disciplinary body is going to need depending upon what the violation is. I mean, warning letters have already happened. If you remember from the workshop, before it gets to this point, that homeowner has had multiple warning letters, multiple phone calls, and multiple opportunities to resolve this. So we're at the point now where the board gets this at a hearing and has to make a decision one way or the other as to what they want to do to dispose of this issue. So I think having a varied toolbox would be very beneficial, because we've learned just in the last couple of years, the few times we brought incidences in front of the board, the board has used different means of trying to resolve it, some beneficially and some not. While I still have the mic, excuse me. Before we look at this, the part, John, that you highlighted in red, that you added, which was failure to submit and receive architectural application approval before making changes, $50. I would like, is Mary Ann here?
Yes.
I would like us to be able to have a conversation on that amount as well before we go forward with that.
Mary Ann, do you have a comment?
There's three of us.
I was kind of hiding back there. Well, $50 seems so meaningless to me. Usually when someone doesn't file an application, that's when we run into a problem. It just happened the other day. They filed applications for everything, but did not file an application for one of the things that we didn't particularly care for. So the no app application is really the most important, and $50 just seems like not a lot of money to be much of a deterrent. $250, people thought it was too high, but don't we have to have a high amount there to say, gosh, I don't want to pay that $250? I mean, in my mind, that.
Thank you.
John? Yeah. May I ask a question here? Cassie, I wasn't here at the beginning of this procedure. I was involved. And we thought just a few minutes ago we might restrict this to architectural guideline violations, and you suggested CC&Rs. When we approached the law firm, Sandra, the attorney, for our instructions, CC&Rs, or was it confined to architectural guidelines for?
Both. They're the
Okay.
same for both.
Okay.
Same procedure, same process.
Okay, so we wouldn't be taking something that was specifically tailored. Thank you.
Another thing that's in this generic document is that I think that the architectural committee anticipates that once it's made a determination that there's been a violation, and the only issue is, should there be a fine, that the board impose it. It's not expected that the board is going to relitigate the whole question of whether somebody violated the architectural guidelines. Is that correct, Andy?
That was the hope of the committee. From what we've received from the attorneys, from Sandra Gottlieb, was that the board does have the authority to look at the actual violation again, but her expectation is, and what's been proven out, is that they follow the recommendation of the committee because they're not the experts on the violation. The committee is, and they levy the discipline relative to the fine relative to the violation.
So the architectural committee is okay with reconsidering whether there's a violation and relitigating that again?
I'm going to go out on a limb and say no.
Well, I would think
But
not
they'd
either,
have to, but I
Mr.
think they'd have to
President.
accept it.
I would think not either, Mr. President, but these were not tailored for the architectural committee, what we have before us. And for example, it says right in the opportunity to be heard that the attorney member has a right to bring an attorney and to make an argument about why they did not commit the alleged violation. So the board with district is going to be saddled with full hearings, okay, the whole fundamental questions of whether somebody plants were too tall or whatever the issue is that's allegedly in violation of architectural guidelines. What I think the architectural committee is saying to you guys is that, look at our CCNR. We're a freestanding committee, with the right to make our own decisions. When we've made a decision, there's an application, and we need then to ask the board to enforce it. We're not saying we're asking the board to re-decide for us whether there's been a violation. And that's what these do. These documents do, and that's the point. They're not tailored to Oakmont. You know, they're kind of, this is a general enforcement policy, not tailored to us in our situation.
You are not sure, but that might be a new requirement to allow that. I'm not sure if that's a new requirement or not, but I'm sure that there's a reason that she put that in there, and I'm sure that that's probably happened in some associations. This is usually over huge architectural issues like building a house that's 6 feet higher than it should be. And then it's got quite a bit of cost to correct it along with the possible litigation. So I think that's why it's in there.
Well, I wouldn't assume that, Cassie. I did research on this subject myself for the purpose of the Abuse Committee, and this distinction between what the Architecture Committee's authorities are and what the boards are absolutely unique. I mean, Oakmont is very unique in the sense of having such a separate and equal independent committee such as architecture. And I don't know that there's any obligation that these matters be relitigated before the board. I just never came across any such requirement in the law.
I think one thing that we may be coming up against is the next item on our agenda is opinion letter on the Architectural Committee's authority. And I think we're all going to want to read that fairly carefully because it sounds pretty fence straddling to me in some of its respects. And in this context, it seems to say that architectural violations in connection with specific provisions of the CC&Rs are something that the board doesn't have any authority over. But since the Architectural Committee goes beyond that in terms of guidelines and policies, which are interpretations, as I understand it, of provisions in the CC&Rs, that there is an opportunity for the board to look at it differently. I'm just raising this for discussion. I don't have any axe to grind in how we go forward here. I just think we need to try and figure a way to go forward and to have some more community input in addition to the concerns that board members are making. Bob?
The attorney cites Civil Code Section 4935. Topic reserved for executive session board meetings, decisions for discipline board function. Yes, I will. The attorney cites in her letter.
A little closer to the mic.
Thank you. Civil Code Section 4935, a topic reserved for executive session board meeting, which inherently means decisions on board member discipline are ultimately a board function. Now, you, and if I take your point, and I'm not sure I do, but I can understand fully, the board is involved in the discipline. The violation has been documented and has occurred. And now the board is and you might be making another point I'm missing.
You got it.
Okay.
You're right. Just complete your thought.
The
board is involved in the discipline
Right.
after the violation has been
Right.
determined to have occurred by the Architectural Committee.
And I think the Architectural Committee and committees of past want to be reinforced by the board and not have it re-litigated.
Right.
They're looking for that.
That's right.
And I see this as the remedy section, the enforced remedy that the board is involved in, not going back and saying, was there a violation or not?
But that's what her proposed draft does allow us, is to go relitigate whether there's been a violation or not. And that's why I'm suggesting this document requires some provisions, tailor it to just be for the Architectural Committee.
Could you show me, because I'm not familiar with, could you show me where in the policy?
Yeah, it does in section right at the beginning of the policy.
I've got a paper copy too, so I'm at an advantage.
Let me find it for you here. Where it says opportunity to be heard, section C,
Is this section 1B that you're talking about?
1C.
1C?
Yeah. It says the member shall have the right to send a letter, send a representative, or appear in person as evidence of why he or she should not be disciplined and/or did not commit the alleged violation. And that is the language that allows them to fight the fight again, okay, that the architecture committee already decided.
That's called due process. They have that right to refight that
No,
fight.
no, they don't. The due process is followed by the architectural committee. They only get one bite. I mean, you can't have two trials. I mean, when somebody appeals a case, they don't go to the Court of Appeals and say, I want a new trial. The Court of Appeals looks at the record and just says yes or no. They don't get a new trial. And then what they're saying here, the way this is structured, they get two trials. They get a trial, they get a due process trial before the architectural committee, and if they don't like the result, they can, and they don't comply, then the architectural committee refers to the board. The board gets to re-decide and retry the whole thing all over again.
Yes, that's the normal course of the procedure.
Well, I don't think it's necessary. Okay, there's no law requirement.
That's just the normal, that's normally the way it's handled, that they get the right to appeal one more time if they want to do it.
The problem, Kathy, is that there's no normal law. This is not normal. I've never seen an association that has an architectural committee with independent power beyond even, that can't be touched by us. And we do. And it was set up by Mr. Berger at that time primarily to get all this stuff off of the plate. You know, let the architectural committee deal with all this stuff having to do with landscape design and all that. We're trying to pull it back into the board. And I just don't know that we have to. And it's certainly not required by any law I'm aware of.
If I were in the position of being accused of a violation, and it could not be remedied through the due process and interaction with the architectural committee, to me, going to the board, I'm still an alleged violator. I don't see myself as a violator. I see myself as an alleged violator because I'm going to make my case before the board and why I shouldn't be fined. I think that's normal and wouldn't get to the board unless, and from the violator's point of view, the alleged violator's point of view, you wouldn't want to put in writing that you are the violator when in fact you're going through another process that requires due process. And
Yeah,
I'm out of my pay grade here
That's
too.
the way, Bob, that it's been done in the past. That typically, there's been a concession that the board can redecide what the architectural committee has done. And we'll take a second look and make another decision. So, that's the practice. And if that's what you want to continue, I just think you need to be aware that you are. And that it's not...
Change subject and get a couple other
I have a
points.
parliamentary
I'd like to,
Can you wait just a minute? We're not going to overlook you.
Well, it's important.
I understand it is, but I want to leave it to the directors for a moment, and then we go to the audience.
Well, you see, some of them are not directors, and that's exactly what the question is about.
Well, but he's an advisor to us, and we...
I'm speaking as chair of an ad hoc committee on abuse that was appointed about 6 months ago to write a report on creating a fine policy and a hearing
Well, all the
procedure
other people about the
for...
fine policy have stepped to the microphone. Marion has not sat up there and talked. She's come to the microphone.
yes, I heard what you're saying. Just please wait a moment. You will be heard. The way I view this is, as a board member, I don't want to be put in a position where I'm trying to outguess the decision of the Architectural Control Committee. They've done a thorough investigation based on their experience, what's written into our GC&Rs and all the other things, and they've made a determination. I am not an attorney, but I view this, when it gets to the board, as kind of like the sentencing phase. And maybe there's some disagreement here. And at that point, someone can argue whether or not a fine or something is too severe under a situation. I'd like to be able to take a look at the case itself and say, okay, well, have these things as a menu that we can choose from to try to match the violation and support the Architectural Control Committee and maintain some semblance of doing what we're trying to accomplish. But I see it as a kind of a sentencing phase. And I don't want to be put in a position as we have in the past of sitting down going over this whole thing again and again and again and again. It just doesn't make sense.
Alan?
Here's a suggestion. Why not at the next workshop, if you're having this kind of difficulty with this issue, what about having Sandra Gottlieb attend via speakerphone? So you could sit here and ask her those questions and she could answer and give you some guidance.
Thank you, that's worth considering. Alan?
There's three things I want to address. The first is that paragraph gives the right of somebody to bring in counsel, an attorney to represent them. And I think that's a very bad idea, and I agree that that is not necessarily a right that they have in this sort of a hearing, this sort of a situation. And I can assure you there are some incredibly bad attorneys who would make a mess of our lives. Secondly, the idea of looking on this as a sentencing hearing or as an appeal where we just look at the evidence as presented at the hearing and to see that it's a rational decision, not arbitrary, and as a sentencing hearing that we look at the evidence to determine what's an appropriate sentence is one way and a legitimate way of looking at it. However, the practical aspect of it is anything that comes to the level of the board, that's a fine or something like that, is going to be a case fraught with dispute. Somebody's got to be very, very upset to bring it to the board because there are built-in expenses that that person incurs prior to getting to the board. And I'm particularly referring to the, the dispute resolution, the second dispute resolution hearing, which requires expense of an independent mediator. So the fact of the matter is that in reality, we're not going to see much that gets here unless it's something that is very, very big. Somebody builds a house or does a remodeling job that far exceeds our bylaws and policies, or somebody is very distraught. And I think those few things are things we have to deal with. That's why we're here.
I'd like to have comments from the audience, but I'd also like to say, if you've got a criticism of my invitation to Hugh Helm to offer his expertise, then I'll accept your criticism. But the board appointed him as chair of a disciplinary committee who did a lot of research on this, and I think it's beneficial, and so I chose to have him have his input. And that doesn't exclude you. I just wanted him to participate as the directors were having that discussion because of the expertise.
When Tony comes in as a person who advises you on the long-range plan, can Josh come and sit as the chair of this communication?
I just have one point. Bill Biggs, Stone Creek Circle.
Thank you.
Isn't the key issue here governing documents? I have the understanding it's a unique situation. Is this working? A unique situation here that you've given the authority to the architectural committee to make these decisions. Why should I can't find a rationale for somebody coming back and establishing a dispute issue with the board, because the board did not make the initial disposition. The administrative status is governed by the architectural committee. If the architectural committee has operating with the approval of the board, then it is not necessary to go any farther. The board has control over the architectural committee, who is on the architectural committee, and how they operate. So to me, it appears rational that it shouldn't go any farther. You don't want to, as a board, have to go and relitigate a decision that your architectural committee has made, is what's the point of the architectural committee. So it doesn't make sense to me. We're getting into a position here where you're making it more difficult for yourselves by trying to carry it too far.
Thank you.
I just want to make it perfectly clear, I'm not suggesting anyone be silent. I'm suggesting that none of us non-directors can come speak from the table. We all have to step to the mic, and I think that's how it should be for all non-directors.
Going back to the no app fine, one thing that people forget is that the $250, once you bring your property or do your application, bring it into compliance, the board can waive that. Doesn't really matter how much it is. It could be $500. You can still waive that if the property is brought into compliance.
Wally Shelp again. In my 5 years on the architectural committee, I can name you a half a dozen times when a resident brought an attorney in to a hearing, both in the architectural committee itself and to a board appeal. Now, unfortunately, I think you have your next item on the agenda should have come first before this item, because the understanding, and I have not seen your current opinion from legal counsel, but the understanding in the past was the architectural committee made a decision. It could be appealed by the resident. The board could come to a different decision from the architectural committee, but they could not force the architectural committee to take that decision. Then they would sit down with the architectural committee, and that committee and the board would argue it out, and the architectural committee never, according to our written CC&Rs and our articles of incorporation, the architectural committee did not have to follow the board if the board overturned their ruling. The only way the board could control the architectural committee would be to fire them and appoint a new committee. But they couldn't make them change their decision. Now, has that changed with any current ruling?
I think that's what we're wrestling with, Wally, is trying to sort this out. That's why it's on the agenda, not because we think this is a perfect policy to adopt. We're just trying to understand the advice that we're getting.
Yeah, well, I'm just trying to make the point that attorneys have always been available to residents at hearings. It's been the practice. Yeah.
But I'm not getting a sense of what the board wants to do regarding this proposed draft that we think. We don't have a motion to publish it. We don't have a motion to ignore it. What's your sense of direction after the discussion?
I'll give you a motion to postpone the further discussion until we investigate further. I don't think we're in a position at all to make a decision today on to adopt anything.
Has the lawyer that we have for the Oakmont community had a chance to take a look at this procedure?
We got this opinion from Sandra Gottlieb and Swenson, and the correspondence is in your packet. I'm perfectly willing to have it carried to our workshop and invite her to join us at the workshop to deal with the range of questions that you have, if that's your pleasure. I'm looking for a sense of what the board wants to do. Excuse me for a minute. I didn't mean to ignore her.
Are you discussing also the authority of the architecture committee, or are you just
now talking strictly about fines.
Just talking about this fine policy.
Okay, because I have no comments on the authority.
We'll go there next if I can get past this item.
So I'm going to take that motion off the table, never seconded anyway, but I would just like to see us not make any decision on this today, go back and revisit it. It's obviously not ready.
But the question becomes, I think, how do you want to revisit it? The manager's made a proposal that we invite the attorney who sent this to us to come and talk about the concerns. You know, that's her time and dollars and so forth to supplement this, or if you've got another course of action you want us to.
Well, let's try to do that at the next workshop, if we could arrange it, and have an agenda item for the workshop, and invite Attorney Gottlieb to join us.
But are we prepared? Do we have a specific list of questions that we ought to develop to make good use of that time, rather than just?
I think Andy, myself, John, I think Andy showed us the way a month ago when we first got an opinion. She had additional questions, which the attorney was nice enough to respond to. We got, I think, full, complete answers. I think at this point, we do have some questions, or some people have some questions. Can those be emailed to it and those responses given to the board in the meantime before the workshop? I see it as an expensive item to tie up Sandra Gottlieb for a specific amount of time on unspecified questions at the workshop. I'd like to be discussed at the workshop, but I would move that the questions that are brought up today and the concerns be communicated to the attorney between now and the next workshop, and we get those responses. Does that seem, Cassie?
It does, but you're always going to have more questions and more questions and more questions, so we can prepare her with some questions that she can research. But what seems to stall here is that, and there's nothing wrong with it, you're having a really good discussion about it, but you're always going to have more questions. And so, to me, the way to move this forward would be to, I don't think she needs to come here. I think we could do it on speakerphone. And just ask her questions at a workshop and put her on speakerphone.
Alan?
I think the primary question we have is, do we need a de novo review with the board on any violation, or can the architectural committee make a final decision and we only do the sentencing aspect of it?
That question was asked and answered by Attorney Gottlieb in her most recent letter. That was one of the major questions that we asked her. And I think what we're finding out here is, regardless, or depending upon which attorney you're going to ask, you're going to get a different answer. We got an answer from Gottlieb that says that the board has the separate and distinct procedures for disciplinary reasons. So the board has the ability to do the fines, and one of the questions I asked relative to that of the attorney was, if the board has the authority to, as the governing authority to implement the fines, do they also have the authority, or must they take the authority, then relitigate the violation? And her response was yes. We asked that question of a different attorney, and the response was no. You do the research tells you, ask different attorneys to get whatever answer you want.
I think Attorney Gottlieb has to see Attorney Malcolm Mann's letter before she comes to that workshop.
Let me ask if it would be possible for each director who has questions after thoroughly reading this small print 2-page document to try and write as specifically what your question is. And in addition, we'll include with a summary of those questions as Cassie and I go through your input. We'll include Malcolm's letter, which is the following item on our agenda, in the information that we go to it with, to see what kind of answer we can get to the conflict that we're facing. So with that, we'll close this item on the agenda, and we'll go to the next item, which is the other legal opinion that we have from Malcolm Manuel addressing the issue of architectural committee decision. And I don't know whether you had the time to read it and think about it thoroughly, but I saw it as a fence straddling. You have a comment you wanted to make that I heard?
I found that letter exceedingly fence straddling. And I think I have an extreme concern as to the authority of the Architecture Committee in relation to the board. Historically, the board has not exerted much authority over the Architecture Committee, but they have had the authority to do so. This is because they have been able to overturn Architecture Committee decision. And there's one paragraph in Malcolm's letter that is so true. In the past, any major change in the guidelines and standards have always been approved by the board. And in one paragraph, and I don't have the one paragraph of Malcolm's decision in regard to that, he says, all such changes are subject to review and adoption by the board of directors. So what happens if the board doesn't adopt them? Then they're not valid. This is an interpretation anybody can take. My interpretation is that the Architecture Committee has to be subservient to the board of directors in many areas, because the board of directors is the only elected body in the community. You have the ultimate authority over the entire process. I think that is the way it should be.
Thank you. Any director comments on this correspondence from Malcolm? I just had it here for discussion purposes, and it just needs to be melded into our continued wrestling with the policy on fines and on the guidelines and standards.
Would you like a second opinion by Sandra Gottlieb?
Any wise answer?
You know, most publications advising boards of directors, you might read, say that we are allowed to act on professional advice. And we pay for professional advice, and if we keep seeking 2, 3, or more professional advices, we may have 2, 3, or more roads we have to travel down, and we have no help at all. And we're more informed, but that doesn't make the board body that continues down into the future more advised. I like the idea of paying for an opinion, discussing that opinion reasonably as amateurs, and that's why I can't sit here with you or Alan to talk about the law at all, or Cassie. But if we start changing horses all the time, we're going to be nowhere. I think we just should decide, probably, instead of comparing attorneys' answers, we should conclude who we're going to on this and take their professional advice and go with it. Also, secondly, I think sometimes we're talking about several different topics as we discussed this. Herm, you brought that up just now, that the board must approve changes in the guidelines and standards. But this, and I may be getting this wrong, don't think that I'm entirely confident in what I'm saying, but we're discussing a fine policy and how that would be connected with the architectural committee. And we're not changing those procedures. So I'd like to narrow the topic here and ask specific questions, as you said, and get them ready and see what we can get from the professional attorney we are paying and is practicing and has malpractice.
I'd like to make one more comment, if I may. I'm going to address the elephant in the room. It is made no, and correct me if I'm wrong on a lot of stuff, but when I look at this overall situation, it comes back to the question, to the answer that I understand makes no sense whatsoever, is why the Architectural Control Committee appears to say from the interpretations that I received, that the board received, and goes back to what Herm said, is why they're independent and from the board. Why, if the board is ultimately responsible for all of the business of Oakmont as elected officials, why is it there is one subgroup within Oakmont that operates entirely independently? Makes no sense to me whatsoever.
You know, I know you guys,
Talk about it, and I stand up for the target of my back, but that's okay.
you think you're unique, and in many ways you are. But all homeowners associations have a subgroup of an architectural committee, and they all work like this. So to the extent that you think you're somehow unique about that, you're not.
Mr. Chairman?
Yes, excuse me, Fran.
Well, I was late. I noticed that item number 2 in our agenda today, in our meeting, actually would provide us the opportunity to further discuss that. And if you would accept a motion to table this for the time being, I would make that motion.
I second that motion.
It's been moved and seconded that we table further discussion of the Malcolm Manuel opinion regarding the Architectural Committee's authority. Any discussion of that? Alan, your question is to when, and there was nothing about the motion that indicated a time frame.
Can I make a comment on that? Sometime this decision has to be made. You can't put it off forever. You have to, there has to be a decision as to just how far the authority of the architect committee goes in this whole aspect. How and when are they subject to the control of the board of directors? Sometime that decision has to be made, and you can't put it off forever.
I certainly agree. I just don't get the sense that we have come to grips with a meaningful discussion of Malcolm's opinion letter of April the 26th, 2014. And so we've got a motion to table this without any specific date. I don't think that helps us very much, but we have a motion to resolve.
Mr. Chairman, I did not mention Malcolm's letter because that's only part of the question. And we are going to discuss, it's on the agenda for this afternoon, the CCNR violation issue. And I felt that it's very possible that we might come out of at least a direction or an answer to what would be put on our next board meeting agenda to vote on.
I call the question.
All in favor of the motion as stated, please raise your hands. The motion fails. by my count, the motion to table failed. It was 3 votes to pass it, and they needed 4, so the motion to table is dead. Now what do you want to do?
Table this until the next workshop and discuss.
Alan, can't hear you.
I move that we table this until the next workshop and then discuss it further with more information and possibly with the attorneys on a conference call.
I don't think you need a motion to it. I'm glad to put it on the workshop agenda. It's a discussion item, so there was no action called for here. But I think you need to think a little bit and give some more advice as to how we address this Malcolm letter.
Withdraw my motion.
Thank you. I will make sure that it gets on the workshop agenda. And that's going to be along with further discussion of the previous item, which was the discipline policy. Thank you. Item 10G is the beauty salon property purchase proposal feasibility study and action. By way of introduction, the OVA Beauty Salon property purchase proposal agreement with the Berger Foundation was conditioned on a 120-day OVA feasibility study. Our study work began on April the 23rd. We've now had time for professional investigation of the building with the benefit of as-built drawings. Architects Weir Anderson have provided suggested layout and elevation designs. We've learned that there are some expensive ramifications to remodeling this 35-year-old building for OVA offices, including both accessibility and installation of a sprinkler system for fire protection. The investigation also included further assessment of what office location would provide the most benefit for both new and existing residents. We're concluding that further investment of OVA director and management time, along with association finances, would be a mistake. As you will note from the list of board goals we approved earlier this afternoon, directors decided it's very important to resolve for the immediate future the long-standing debate regarding the desirability of owning versus leasing our required administration offices. So with this introductory background, I think Bob Giddings and Andy Altman have a motion that they'd like to present for board consideration.
I'd like to move to drop all pending negotiations for development of association-owned administration offices by terminating our conditional contract for purchase of the Berger Foundation Beauty Salon property and by canceling our contract with Archeologics for Phase 3 design and development of a central building complex.
Second. Seconded by Fran. Discussion or questions by the board?
I have questions. I don't know that we have enough information to make comparisons as to what will cost, office building cost us. You're saying now that it looks as though the beauty parlor salon will be too expensive compared to what? What do you have that says it makes it too expensive? Is there anything in the mill right now that says you can get an office building built for less than what the beauty parlor would cost?
The reason that a statement was made, Herb, is simply that the amount that it's going to estimate to do the job is in excess of the budget that our board discussed in hiring architects to take a look at it for us. Alan?
It's my understanding that we do not have the amount that from a contractor and the architect as to what it will cost to build. Is that correct, Cassie?
Yes, we don't.
Build or to remodel?
I beg your pardon? To remodel. Do we have that amount?
No, we don't.
So we haven't, we've paid for a service, we haven't got the service, and you want to not get what we paid for. Doesn't make any sense. I mean, at the very least, we should have Cassie find out what the amount is, so we can find out what we're dealing with. Secondly, I would very much like to postpone this whole matter of the office building for 6 months, and including the beauty parlor, but to abrogate the contract rather than try to negotiate an extension without any cost, or just talk to them, that is the Berger Foundation, about the situation that we need to find out what the West Recreation repair job is going to cost, which it may bankrupt us, or at least delete our funds significantly, so that we're not able to at this time to envision an office building. I think we should be able to at least have that kind of a discussion with the Berger Foundation. And to abrogate it, just to tell them, I mean, that's just not a good policy. The Berger Foundation has a lot of things that we are interested in, not the least of which is the access to Annandale and the West facility, and we may want them to continue to talk to us. So I suggest that we explain our situation. We need to find out some more things, and we can't do anything until after the first of the year, and we'll make a decision then. And then we should find out what we get the service that we paid for. I mean, calling it off is absolutely silly.
I don't happen to think it's silly at all. And I believe that we've wasted far too many OVA resources, too much management time, too much community conflict to carry this on 1 minute longer. We know that we have a project under consideration that can't represent a unified support of this board in terms of spending $1 million, and can't answer our questions properly. And we've got the opportunity to continue to lease where we are for up to 6 more years while we use our energy and our resources to address the laundry list of facility maintenance activities and improvements that we've identified through our walkthrough with the manager and with the maintenance manager, and through the input that we've had from the community, and to continue to perpetuate a myth that we're going to be able to come up with a satisfactory, financially beneficial solution to providing an association-owned office building is a crime.
Well, you're not addressing the matter that I suggest that Cassie make a phone call to, or receive a phone call from the architect that we hired and paid for to get and who's supposed to give us a report, to get that final report. I mean, we may not use it, but we've paid for it. Why not get it? I don't understand it.
I didn't say we shouldn't get it. I'm just saying it won't make any difference in my judgment.
Well, that's fine. You know, I'm saying that, in my opinion, we should not go ahead with that project now, period, because we have so many problems in Oakmont and so many issues that distract us, that we cannot have something like that when we have major problems that need to be dealt with, such as the Berger Center, such as the West Rec. And I don't want to see us wasting energy when we have to focus on the West Recreation Center, when that stuff starts coming in and we have to start making some serious decisions about that. Hopefully there won't be any. We don't know where we're going to find when we tear down the walls, do we? When we open it up. We're hoping we won't find anything.
I think it's important to underscore something that John said, and that is the motion is to terminate the agreement with the Berger Foundation, not with Weir, Anderson, and the subcontract they're getting for estimates. If we pay for that, we will get that product, just as we have the product that we had for what was called the CBC. We own that information. We have that up through phase 2. So we should get that, as you said, Ellen, because we pay for it, and we will have that as property.
Our
That's
property.
your understanding of that part of the motion, that we terminate any action on the contract, is that we still get that, the architect's report. I think that's a good idea.
Yeah, it doesn't involve Weir Anderson, the architect. The motion does not include them.
And how should I put it? We should be very delicate on how we deal with the Berger Foundation. We have generally impressed them as people that don't know what they're doing and who are.
I have a further question.
Wait just a minute, Alan, are you finished?
No, I'm just saying that I would highly recommend that we be very delicate and on how we deal with them rather than, and I agree that we should not go through with that project now, that we not alienate them further in abrogating that contract. There's various ways to do it.
I think you're right, and I think we should use your expertise to help in that communication process.
Yeah, my question, is a further question. Am I hearing that we are not going to look at any more office options that are available to us, that we are now going to continue with the leasing of the present property?
Yes, that's what the motion would cause to happen. We're going to put away this amiable discussion that's gone on since 2004 about owning an office building. It went on once with Tiernan Figueredo. It went on again with the first edition of the CAC. It went on again with the CBC. And now we've moved on again and we're looking at the Berger building. I'm saying that I believe we serve the association better by simply putting away from any of our discussions for the foreseeable future, pursuing owned OVA office property and taking a breathing spell from that and not spending any more money on it and focus our attention on the work that we're trying to do in a classy fashion to improve what we've got. Pat, pardon me, I'm not ignoring you.
I knew you weren't. I completely agree with the motion. I think a number of sites have been looked at over the years, and I just think that we all have limited time and we have limited resources, and so I commend Andy and Bob for making the motion and hope the board accepts it.
Excuse me, I'd just like to comment on our existing office space. I agree fully that we should delay anything to do with a new office involved. However, there are deficiencies with our existing rental office space. Are you contemplating perhaps putting a little bit of money into remedying some of those deficiencies? That would be my only question.
All I can say, Herm, is I think that the manager has some ideas along that line, but we're just trying to deal with getting over the hurdle. And if she wants to come up with something that we ought to investigate regarding renewing that lease, the first 5 years of our lease expires in April of 2015. So we have a renegotiation for that lease that could well work into some kind of improvements that she would want to recommend. Call for the question. All in favor of the motion? Motion passes unanimously. Thank you. Item 10H, publication of petition signers' names. This is not a discussion, and it was put on the Med agenda this way specifically for this reason. This is not a discussion of the top lot petition. This is a discussion of what the association's policy should be regarding the publication of names of people that provide input on association matters. In the case of the Long Range Planning Committee's report on their investigation of the tot lot, they specifically identified specifically identified the names and the comments of 36 email inputs that they had regarding their research. They specifically identified 3 social media buzz comments, and the person that made it. Specifically identified 32 next door social media commentators and their names. They identified letters that had been written. They said they had a report from the grandparent club that there were 100 names in support of a tot lot. And they reported a petition that had been circulated with over 200 names opposing a tot lot. The question's been raised by a resident that I hope we will discuss is, what's the association's policy when it comes to identifying specific names associated with any kind of project or petition input? We don't have one. It's simply the careful work of a committee trying to keep us informed that brought this particular policy subject to our attention. And so I'm looking for what kind of action, if any, we may want to take regarding the publication of people's names and their opinions about a particular form of input to a committee or to the board. You'll notice today, for instance, when we talked about the pool and billiard room situation, I didn't mention any names, but you all saw what the names were on the document. But that something came directly to the board, not to a committee. I don't know what kind of policy you would advise us to adopt, or what kind of action you would say we ought to take and not adopt a policy regarding people expressing their opinions and being identified or not identified. That's why it's on the agenda.
John?
Yes.
I don't see what value adding the names to any of those issues would bring to the issue at hand. I mean, it should be evaluated based on its own merits. No need to bring a name in.
I like Herm's response, because the opposite means that we have to buy another 3-ring binder and have another policy, and then an amendment to that policy, and a rejection of that policy by a future board. I don't like that because of that reason. I think if somebody signs something, yeah, they should own up to it, I guess, if there's a need, or be aware that it might be publicized. But if they're given that petition saying that it was confidential or will not be published, that's another thing entirely. And I don't think we wanted to get into that kind of control business or develop a policy or an ad hoc committee to look into a policy for. It may not be the smartest reaction. I just don't want to touch it.
I guess that leaves me, though, with the question, Bob. Should we at least advise committees in the future to refrain from publication of email names and things of that nature? Because that's what brings up the problem. One person who got identified wants to know what the other side was that wasn't identified.
It seems to me that petitioners can make that decision themselves. If they don't want to be identified, then they don't have to be identified except to the committee. And if they want to be identified or they don't care, then that's fine. The committee can publish it or whatever.
I didn't raise my question properly. I'm raising the question of what our advice should be to our committees about publicizing any names associated with opinions. Because this came up simply because names and opinions were individually identified for a large number of emails.
If somebody asks not to be identified, I think we should not identify them, but they can still voice an opinion.
I may wear out my welcome here. And I've said this before in a board situation. Well, one of the people I admire in history once said, "You don't represent public opinion, the board represents the public. And the difference is there that you're looking for the best result for the community as a whole. And we have, as examples, we have maybe 200 to 300 people in the tennis club, a huge minority in the overall community, but a huge activity. We have maybe 40 people playing pickleball, 45, a huge minority, but we're thinking of the future and we're thinking of their needs. So the board can't be anyway overly influenced by petition, 100 or 200 names on it, on any given thing, and that's why I like Herm's response from the beginning, because I think you were saying we take it on its merits and what's best for the community, not how many people, like a small minority that comes out and says, we think this, we think that, as good as their opinion may or may not be.
Yes.
Tony Lockowitz, speaking, you're all. On.
Someone shut me off. Speaking as the chair of one of the standing committees for Oakmont, I think it would be very helpful to have a written policy going forward, because these issues are not going to go away. In fact, with the age of social media websites, emails, and multiple means of communication and discussion of public issues or issues that affect Oakmont, it's not going to get any simpler, it's going to get more complicated. A written policy, one way or the other, clarifying what things can be held in confidence and what things or names should be made available to the public, to residents, needs to be spelled out. And I'm telling you right now, I don't have a policy in mind, but it's something that we need as we go forward. I'd be happy to work with anyone to develop it. Other members of standing committees may have run across the same problem in the past, but we need to do something and put it in the policy for committee procedures, which we have. I checked it when I wrote that report. It's silent, totally silent on the matter of publicizing names. Thank you.
Thank you. John?
One way we might be able to address this, just to throw it out as an idea, is that we have a standard petition form you can pick up at the office. And on that form would be space for the usual things, but there'd also be a column for private or okay for distribution or something to that effect, and you check it off. And that petition, official petition form that you pick up could be used for any particular purpose, but those are the only ones that would carry any weight as far as wanting to count towards something, is turn in an official form, but it already has the built-in choice to opt in or opt out.
Yes, Bridget?
Actually, we never ever had a problem in all these years. This is the first time that the emails were released on the internet. Before, we never had any problems. It never came up. So how are you going to go around asking people, and then you have to check off whether they want to have it released or not? So a lot of people say no, the other ones say yes, that makes it even more complicated.
Mr. Chairman?
Yes, Fran?
As city politics goes, the importance is who is circulating the petition. And I really feel that here in Oakmont, that anyone who wants to circulate a petition should, as John pointed out earlier, should sign up in the office and take out, so that we know who is circulating those petitions. But as far as making the petitions after they have been filled out public, I would not go along with that. This is a civic duty, or I should say responsibility, on anyone who feels very strongly on an issue And there's no reason at all why one needs to know exactly who is on that. But the fact that they are registered as an official collector of signatures is important to all of us. Thank you.
Well, thank you for the discussion. If there's no sense that any action should be taken, things where they are. The next item on the agenda is the white paper from the Architectural Committee on Artificial Turf. I really appreciated the extent to which the Architectural Committee documented their decision regarding artificial turf and the technical detail behind it. And I think Mary Ann had some additional information that's come in since the committee put that together. You want to share that with us?
Thank you, John. Yes, I got this morning, and I think you have a copy. But if you don't, I have some here. Does everyone have a copy, or do you want to sit down? It's from the city of Santa Rosa, why artificial turf is not rebated. Many of the reasons are the same thing we have on our white paper, but I'm going to go just read it for the audience. The City of Santa Rosa's Green Exchange Rebate Program improves landscape water use efficiency, reduces peak demand, and encourages holistic landscaping practices that will minimize environmental impact. A holistic approach to landscaping works in harmony with the natural conditions of the Russian River watershed, fostering soil health, conserving water and other valuable resources, reducing waste, and preventing pollution. Artificial turf is not consistent with the holistic landscaping approach and therefore is not rebated through the Green Exchange Rebate Program. And they go through and list their reasons. This will be in the architectural office and will be given out to anyone that is looking for artificial, along with our artificial turf criteria.
Any questions of the Architectural Committee about this? This is really in response to our request that they document, and do you plan any article in the newspaper that might share any of this?
Yeah, it's a good idea. No, I hadn't thought of that. The artificial turf criteria should be published one more time, but we can do an article pointing out the city's, the water department's rebate program.
Your call, but you may want to thank you for putting it together.
Thank you.
Do we need permission from the city if we wanted to duplicate the article on our paper? Because it's well stated.
It's published on their website, per Kathy. You can say that it's published in the website. I think you can go to the website and pick up this article.
The final item on our agenda is the account referrals for collection. We don't need to identify them individually, but may I have a motion to refer the accounts in our packet for collection?
I'd like to add something. Usually I have a chance to get in touch with these people, so when something's in front of you to approve, if you're going to approve these, could you approve them subject to me verifying that I can't get in touch with these? I haven't had a chance to do it.
May I suggest we simply defer them then, rather than tentative approval? Any problem with that? Defer item 10J. Is there any other unfinished business that we've overlooked?
Since we didn't talk about the manager's report, item number 8 on our agenda, because copies were provided to everyone, I'd like to bring it up at this time, and I think I owe a public apology to our manager, because I think that the umbrellas and the furniture at the east are simply beautiful, and I want to thank you for going ahead with them. I was just trying to save money, And, but the pleasure that these improvements are giving to other people are not worth a penny picture. The other thing I did want to mention in regard to, and I think it would be primarily up to the manager to handle this situation, is I stood for 45 minutes out in front of the main pool, and I watched the people going in, and during that time, I must have seen about, there must have been 15 adults that were going into the pool, and of the 15 adults, only one person ever used their key to get in. But we must have had at least 15, 20 children. There were at least 2, they looked like not city, but Oakmont employees who dashed through those gates, and the gates remain open, and all of these other people who were standing outside waiting to get in, walk in. I mean, it seems to me that if the manager had time to look into that, we might be able to better control the use of our pools. I think we only encourage Santa Rosa people as a whole to come out to Oakmont to swim in our main pool by not enforcing the use of the gate or making the gates efficient so that they close immediately after somebody comes through. Thank you.
Thank you. Being nothing.
Comment. And that is that I would like to recommend that an article be placed in the Oakmont News regarding Cassie's attempt to get the message across to press Democrats, but it got edited to such a point where only part of it came in and seemed to be biased. And I would like if people in Oakmont to get a first-hand actual report of what was covered in that interview.
If you haven't had a chance to check it, I think her Friday afternoon message did a nice job of that as well.
I agree with that, but I don't know if the whole Oakmont community knows that.
Herm, I want to drop it. I just don't want to dust it up again. But thank you.
Meredith, do you have another comment?
I do. I have another comment. Actually, I have been told from some pool goers that there are people attending the pool who are given a card by the resident, and these people don't even live here. So maybe when they go on vacation, they give it to their neighbor. So maybe something like that could be put in the paper, that that's not permitted in response to what you said. But what I came up with, I'm a little slow in processing, so the discussion over the petition being made public, I was thinking, in this day and age, anything we write on social media is not private. I mean, that's a given. We should all know that. Any email we send is subject to who knows who. But if we have a contentious issue where people are out petitioning, really emotional about something that's going on, I would hope that the board would take it seriously and have some kind of public forum where we could talk about it. And also, if necessary, that we would vote by mail if we had to, if it remained unresolved. Because some individuals just won't give up. And it just keeps things going.
I'm really going to have to call it to a close. We're beyond that point, and the board has an executive session to address. So we're through, Bridget. Thank you. The meeting's adjourned.